Okay, we brought you guys together to have a discussion on the Bill of Rights. Why don't we just start with the basics? Why do we need the Bill of Rights?
I don't think that you should limit everyone's rights.
Saying that we shed our rights at the door of our school.
What the Bill of Rights is that's everyone in the world's basic human rights. Once we start picking apart our rights as individuals, our whole system of democracy is just going to crumble.
Who has the right to draw the line?
You don't have unlimited rights.
If you weren't read your rights.
It's a technicality. By allowing people to express themselves, it's just all the more power to the Bill of Rights.
It's too broad.
The Bill of Rights is just basically the list of the basic rights each individual should have. As time progresses, the rights will be interpreted more and more in more specific ways.
I think the concept of a living Bill of Rights is very important because somebody once said the Constitution is just a piece of paper. By itself, it doesn't do anything. The Supreme Court has never laid out fully what the rights are of an American citizen or a resident of this country. They do it case by case. So our rights grow in very small steps. It only has meaning, it only has vitality when people act in ways to bring it to life. And very often, these are ways that bring us into conflict with authority. In 1965, when the Vietnam War was the biggest issue in this country, there was a proposal by Senator Bobby Kennedy for a Christmas truce and an end to American bombing of North Vietnam while they pursued the peace process.
Mary Beth Tinker was an 8th grade student in Des Moines, Iowa, who wanted to peacefully protest the war.
Mary Beth was one of a group of students in Des Moines who wanted to show their personal support for that truce proposal by Senator Kennedy.
So she wore a black armband to school. She and her brother both did. She was suspended immediately, and they believed that the reason was that they thought it would cause violence and they thought it would cause a disruption in the classes. And actually nothing ever happened. There was no kind of uproar, but the school board said they wanted to prevent one.
The Vietnam War was on the news every night. And a lot of high school kids were graduating and being called up to the service in my neighborhood, and so we knew quite a bit about what was going on. I was a child, and I was really upset to come home and see these pictures on the television of children being bombed with napalm. It was very upsetting.
I mean, she wasn't hurting anybody. She wasn't trying to impose her views on anyone else. She just wanted to peacefully protest the war.
I agree that I am totally against the war, but how can you say that you're not imposing your views on other people by wearing such a band? Because the whole point of wearing a band is so that you express what you want to on others, so that others can see what you're.
But it could express.
You're expressing. You're not saying by expressing your views. She wasn't imposing them on anyone else. She wasn't saying, okay, you have to believe what I believe because this is what I'm expressing. She wasn't doing that. She was just, like Barry said, she was just saying, hey, this is what I think.
A lot of people were very mad about it. On New Year's, or on Christmas Eve, I think it was, we got a phone call that the house would be bombed by morning, and someone went on a local radio station and said that if anyone wanted to go kill my dad, that they would pay the court costs, to defend the person, whatever. And then I was leaving for school one day, and someone called and asked for me, and when I got on the phone, they said, I'm going to kill you. And
Oyez, 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 all persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Going to the Supreme Court is a historic experience. It was intimidating.
Why did they wear the armband to the class? To express that message?
To express the message, yes.
To everybody in the class?
To everyone in the class, yes.
And everybody, while they were listening to some other subject matter, was supposed to also be looking at the armband and taking in that message?
Well, to the extent that they would see it, but I don't believe there was any, I don't believe that the...
Well, it wasn't, they were intended to see it, weren't they?
They were intended to see it in a way that would not be distracting.
And to understand it.
And to understand it,
and
yes,
to absorb that message.
And to absorb the message.
While they're studying arithmetic or mathematics, they're supposed to be taking in this message about Vietnam.
Well, except that, Your Honor, I believe that the method that the students chose in this particular instant was specifically designed in such a way that it would not cause that kind of disruption.
I suppose you would concede that if it started fistfights or
something of that kind and disrupted the school, that the principal could prevent the use of them.
The suggestion I believe we're making, Your Honor, is that there should not be any special rule for freedom of expression cases for schools. Now, that would mean that the general terminio type response, that the state first has an obligation to try to move directly against those causing the disruption rather than to take away the First Amendment right to free expression.
The majority of the court, in a very strong opinion by Justice Fortas, said, schools are not enclaves of totalitarianism, and students do not shed their rights at the schoolhouse door. So the court had a very strong opinion in this case, upholding the right of the students. And the dissenting opinions were equally strong. Justice Hugo Black, who normally supported all First Amendment cases, was very firm in saying that this is different because these are students in a school and they could disrupt the school. And what goes on in a school is almost sacred. You can't disrupt it in any way. There have been other Supreme Court decisions that sort of undercut the Tinker decision and made it more difficult for high school students to express themselves, to publish what they want, to hold meetings and demonstrate.
I don't know, I can really appreciate people who do that because it takes a lot of courage. Like, she had death threats, and things like that happened to her. I think she really took a stand. Mary Beth rocks.
I'm proud if some teenager somewhere thinks that I rock. That's pretty great. And if I've been an example at all for teenagers or for kids, I'm proud of that. If there's something in my life that I've done to inspire other students to stand up for themselves and to have principles and to take a stand, I'm very proud of that.
Joey Johnson is a professional political agitator, and I think he'd probably agree with that. He's very, very committed to his radical politics. And like most political organizers, he wants as much media attention as possible. That's how you reach people, how you get your message across.
So we wanted to disrupt and expose, condemn, dramatically go up in the face of that whole, disgusting, ugly outpouring of jingoistic chauvinism.
In 1984, when the Republicans held their convention in Dallas, Joey Johnson and a fairly small group of his followers, the Revolutionary Communist League, had demonstrations in Dallas.
So we went there. There was a lot of different kinds of youth there. The Revolutionary Communist Youth Brigade, we came there from different places in the country. There was some anarchist youth that came down from the New York area and from the West Coast. A lot of people migrated there.
He also is a person who, for reasons most of us don't understand, has a real contempt for the American political system. And he found a way to express this in a fashion that grabbed media attention that was almost guaranteed to blow things up.
Joey Johnson burned a flag outside of the 1984 Republican Convention, which violated a Texas law against desecration of the flag.
They had flags all over the place. It was a real part of the choreography. The flags, decked out everywhere, and some of them, I think, rather short-sightedly, were hung kind of low, on these poles, and some of them just got ripped off the poles by people in the protests, and they brought them downtown in front of the convention center as close as we could get, and they got burned. Some flag got burned.
There's a Texas state law that prohibits desecration of the flag. He was charged under this law, and in fact, he was convicted and sentenced to a year in prison, so it wasn't a trivial matter for him. He could go to jail. And so this was a case in which there was a criminal prosecution for an act that he claimed was simply speech. Joey Johnson was one of the people who, I think, from the very beginning, wanted as much attention as possible. If his case was going to the Supreme Court, great. He'd get on television.
It's like in basketball, when you're playing a really intense game of basketball and you're in the fourth quarter and you want to go up in the face of the enemy, the other team, really slam dunk, slam dunk to make your point. You know, I think that that's what this case was. It was a chance to really go up in the enemy's face and express enormous contempt for their system, you know, and their holy symbol, you know, the American flag and the whole empire that it presides over.
William Kunstler, of course, is one of the most famous lawyers who appeared before the Supreme Court. Kunstler, in this case, was really at his best, I think, in oral argument, because he was sort of conversational with the justices. He focused on the real question of what is the flag? How do we define the flag? Is there a standard flag, you know, the 13 stripes and the 50 stars, or can the flag be used for any number of purposes, particularly commercial purposes?
I noticed that Barbara Bush wore a flag scarf, for example. There are flag bikinis. There are flag everything. There are little cocktail flags that you put into a hot dog or a meatball and then throw in the garbage pail. They're flags under the Texas statute. They don't have to be made out of cloth. But I think there are all sorts of flags used commercially. I'm not sure in my heart whether I think there's any control over the use of the flag.
This was a 5-4 decision in the Texas versus Johnson case. It was one of the cases in which there was almost complete split between the majority and the minority. They were not haggling over little details of constitutional law. They had entirely different ideas about this case.
And it tests the First Amendment, whether you can see a harsh thing like that, which war veterans complain about, which touches a lot of people who do have certain reverence for the flag, to have that burnt, desecrated in their eyes, and yet protected by the First Amendment, I think is a hard nut to swallow, but it's the kind of nut that the Founding Fathers wanted us to swallow, because they said that it's the hard words, not the soft words, that need protection.
Justice William Brennan wrote the majority opinion in this case, and what Brennan wanted to do, I think, in this case, was to establish as a principle that the flag is another form of speech, and that like all forms of speech, it can be used in any number of ways. And in fact, Brennan went to great lengths in his opinion to say that if there's a bedrock principle underlying the First Amendment, I'm quoting, I think, almost verbatim here, it is that the officials cannot tell us how to speak or what to say. The dissenters basically said that whatever free speech rights people have, there is one important exception, and that's the flag. And the flag is an exception because it symbolizes our nation. It's sort of the one tangible symbol of the nation.
I mean, I'm not saying I'd go out and burn a flag, but I think by allowing people to express themselves as they wish by burning a flag, then it's just all the more power to the Constitution, to the Bill of Rights.
The flag itself, if you look at the actual what the flag represents, it represents the freedom to burn the flag.
It's ironic that the country who is giving him the right to burn the flag, but he has so much disrespect for this country to burn the flag. He doesn't deserve the right to burn the flag.
Well, see, my point throughout this was not to like wrap myself in the First Amendment or in the Constitution, because I think that it has definite, it's too kind to say limitations. The means for molding and creating public opinion or being able to express yourself are highly, highly monopolized. If you look at the media and the major communications corporations, and that's not at all inconsistent with the First Amendment, right? And that's the point, is that the First Amendment is as much about the rights of the defense of property, the rights of property, as it is the rights of individuals, even more so the rights of property.
It's an interesting question. Should the First Amendment protect the people who don't like the First Amendment, who don't believe in the First Amendment? When we say people like Joey Johnson who burn the flag or people who commit crimes shouldn't be protected by the Constitution, what we're really saying is that if we ever get in trouble, we're not going to be protected.
Josh, the irony is what makes this country great, and like you said, it's ironic that the same Joey Johnson, who is against the First Amendment, is the same thing that protects him. It's all what makes this country great, and I think it's great also that you feel the flag is such the way you feel about the flag. And to be honest with you, I do too. But I feel that that because the way I feel about the flag, I feel that people should be able to burn it.
But on the other hand, it also is a symbol people hold close to their hearts. And if they see someone burning it, they get horrified.
Burning the flag, just the act of that, it's treason in my mind.
If you can make a crime out of burning a flag, can't you make a crime out of criticizing the government? Because in fact, that's what burning the flag is. It's criticizing the government and its citizens. So that if we start making these exceptions, where are we going to stop?
Okay, you have the right to remain silent. If you choose not to remain silent, anything you say can be used against you in a court of law. You have the right to an attorney, and if you can't afford an attorney, one will be appointed to you, or whatever, by the court of law.
Ernesto Miranda was simply a drifter. He was a guy who lived in Phoenix. He was illiterate, in fact, had no real profession, and just scraped by making a living. And he was also a sexual predator. He had abused a number of women. It was what the police refer to as a little pressure. They didn't physically abuse Miranda. They didn't threaten him with dire consequences. They simply said, you really need to cooperate with us. It'll be better for you if you do. It was just a matter of a few minutes before very skilled police work persuaded him to talk about the crime. Now, he was illiterate. He had no idea he had any rights at all. And of course, he wasn't told that he had any rights at all. He was sentenced to a fairly lengthy term, I think 20 years in prison. And the American Civil Liberties Union sort of picked his case as a test case.
Is there then a right to a lawyer? I think that the man at that time has the right to exercise, if he knows, and under the present state of the law in Arizona, if he's rich enough, and if he's educated enough to assert his Fifth Amendment right, and if he recognizes that he has a Fifth Amendment right to request counsel. The police, at the very least, had an obligation to extend to this man not only his clear Fifth Amendment right, but to afford to him the right of counsel.
And what would the lawyer advise him that his rights then were?
That he had the right not to incriminate himself, that he had a right not to make any statement, that he had the right to be free from further questioning by the police department, that he had the right at an ultimate time to be represented adequately by counsel in court, that if he was too indigent, too poor to employ counsel, that the state would furnish him counsel.
Well, Warren picked that case to write an opinion, I think, because he was a former county prosecutor. He knew exactly how the police worked. In fact, his opinion was full of excerpts from police manuals, how to interrogate suspects and how to get confessions. And Warren knew from personal experience that the police, even with good intentions, can almost always get somebody to break down and talk. We call them Miranda rights because they came right out of this decision. Whenever the police stop somebody and read them their rights, usually off a little card that police officers carry around, this comes straight from Ernest Miranda's case and from the Supreme Court decision, which almost wrote word for word what these cards would say.
In this country, you're innocent until proven guilty. And plus, we do have rights for criminals and the accused. And, we don't know necessarily that they're a criminal. And, we're not giving excess rights to the criminals by having Miranda rights read to them. It's the fact is that they're not criminals until we find out that they are.
It's a technicality. I don't think that a convicted murderer or convicted raper or convicted anything should get off on a technicality. I mean, it's minor compared to the crime that he did.
One of the things people have to realize is that rights do not depend on the character of the person who claims the rights. Bad people have rights just as much as good people. The real question of rights is if they're applied across the board.
But you can't jeopardize, the whole country's rights just for, so the cop's job will be a little bit easier.
Alex.
This case isn't saying if you're not read your rights, you're dismissed and you can go home. It's just saying that your confession isn't admissible in a court of law. That's all it's saying. And there is enough evidence. If you've committed a crime, there should be more evidence than just your confession, which there was in Miranda's case.
He was tried again without the confession and convicted a second time on the basis of the other evidence against him. and he served another lengthy prison term. Well, the story of Ernesto Miranda has, I don't know whether you call it a happy or a sad ending. After he was released from prison, he got into a barroom fight and was stabbed to death. And what's ironic is that of the two assailants who were apprehended after this fight, the police read them their Miranda rights straight from the card that Ernest Miranda was responsible for starting.
Bridget Mergens, who's a high school student who wanted to establish a Bible study club after school, at her school. And she went to the principal to ask for permission, but the principal refused her on the basis of the Establishment Clause.
It says Congress shall make no law respecting an establishment of religion, that is the government sponsoring religion, or prohibiting the free exercise thereof, that is people exercising their religious rights. And these can come into conflict, as they did in the Mergens case.
At the very beginning, my family was a little concerned because I think they could see that it was going to be bigger than I could see. And they were, are you sure that you want to do this? And as soon as I said yes, then they were right behind me and they said, okay, we're all in this together. I had no idea that there would be a problem with having a Bible study because, like I said, other schools had Bible studies in my area, many schools.
There are so many clubs, like the chess club, the Korean club, whatnot. Why can't you have a Bible study club? People who don't want to come don't have to come.
The school seemed very adamant about wanting to keep a wall of separation of church and state and not introduce any clubs of political, philosophical, or religious nature at all to the school. They felt if they were to do that, then they would be saying one religion was better than another or one political group was better than another. I think they just wanted to stay very neutral.
Yeah, I agree with Jungsuk on this one. It's not as if Mergens was asking for any special privileges. She just wanted a place so she could have her club. How different is her Bible club from a chess club or a club relating to some kind of culture?
Supposing you had a French club, but you had no French classes.
The absence of a French class does not mean the absence of a foreign language department. There are many education...
Well, say there's no foreign language department. Let me push you, but you still want to have a French class on the theory that it's the kind of activity a school can sponsor without getting into all these sensitive issues.
If the club's goals and objectives were instruction or discourse regarding the French language, then I would agree with you.
And so the argument really focused on what's a reasonable regulation of school facilities. You can't let everybody use them whenever they want. On the other hand, if you pick and choose between groups, you might discriminate on some basis that isn't constitutional.
Oh, it was a great feeling to have an 8-to-1 vote, because then there was never a question of whether or not this was the right thing.
Justice O'Connor is very firmly committed to the idea that the courts have to balance the rights of people to practice religion and the rights of government to accommodate religion. And this was a case in which she favored accommodation. There would be no disruption of the school practices by allowing the clubs to meet. The school wouldn't officially sponsor it. So in this case, the free exercise claim was more important than the Establishment Clause. The dissenters in this case felt that schools should be free from pressure to use their facilities for religious purposes. And that, in fact, if you let one religious group, use it, you'd have to open it up to all. And then you might get into the unfortunate situation of having to say, well, you can use it because your views are okay, but you can't because we don't like yours. What if a Satan-worshiping club wanted to use school facilities and they have a religious purpose? Do you have to let them use the facilities as well? And what the dissenters said, in fact, was schools should be out of the business of letting religion use their facilities for any purpose.
Once you mix religion, once you get a Bible club in there, then they'll be saying, why don't we have school prayer? But it'll be non-denominational. You know, it'll be anybody can meditate if they want. Okay, now let's have in this school, let's say the Lord's Prayer.
There has to be a line drawn, and I totally don't agree in parent schools and making everyone participate. That's wrong. No one should have to participate if they don't want to. But she just wanted to start a club and discuss the Bible with some other people who were interested.
Where you draw the line between church and state, because they're saying you're not allowed to mix religion with school. But if you look at it, I mean, you do it all the time. Up until 10th grade, it was mandatory for us to say the Pledge of Allegiance in school. I mean, one nation under God. I mean, if that's not religious, then what is? And then there's, it's like, if you look around, choirs are allowed to sing Christmas songs and other things, but where's the line drawn?
I think Bridget Mergens is a lot like Mary Beth Tinker. They're both high school students, and this is very common. You get into a situation, you feel that you have a right, and you take some action to claim that right, but you don't know what's going to happen.
I don't think of myself as a hero. I think of the case as a big case, but I differentiate the two.
You're going to be sort of swept up, and groups are going to attach themselves to your case, groups on the left or on the right, and they're going to take this case and use it as a vehicle for their own purposes to bring issues before the Supreme Court.
Was I a hero of the revolution? I think that's kind of a loaded word. I think a lot of people, I met a lot of people that they wish they were up there.
I don't think many people realize that there's often a very personal cost to these cases, particularly one that stretches on for years and goes to the Supreme Court. Many people, Mary Tinker was one, other people have endured a lot of hostility or abuse.
There are other people in history that have inspired me, that have done things that seemed unpopular at the time, but have moved us forward. And I think that's where my sense of responsibility comes from, that we're all part of the world, and it's our responsibility to try to move the world forward.
It's not an ordinary person that can put up with this kind of tension. So I think in many cases it's an extraordinary person who may look ordinary on the outside, look like you and me and everybody else, but there's something inside them that says, I'm going to do this. It's important to me, and it's important to other people that I take this stand and stand up for my rights.